Welcome, Facebook Live viewers. This is the weekly Bond and Botus Facebook Live. We appreciate you joining us again this week. We are going to talk about a very important topic today. We've discussed student loans in bankruptcy in the past, but something new has happened. Legislation has been introduced in Congress with sponsors from both sides of the aisle to again make student loans dischargeable in bankruptcy in certain circumstances. Now, this is not an absolute provision for discharge of student loans. So we're going to get into the details today, and we are very fortunate today to have one of the nation's experts on this issue, somebody that knows more about it than anyone I know, and that's Ed Boltz. Ed, thanks for joining us today.
Thanks for having me, Brad.
So for our viewers, Ed practices in North Carolina. He's with the John Orcutt Law Offices. Ed manages the firm, and I've known Ed for many, many years. He is well respected nationally. He has spoke to groups of attorneys, judges, trustees all over the country. He's testified before Congress. Ed currently serves on the board of directors of the National Association of Consumer Bankruptcy Attorneys, and he was president of that board for 4 years, I believe from 2013 to 2017. John, if I have this right, you attended undergraduate school in St. Louis. You attended, Washington University, and then you got your law degree at George Washington University, and you finished law school in '96, and have pretty much been practicing consumer bankruptcy law since that time. What else is there that's important about your background for our viewers to know, John?
I think
Ed, I'm sorry.
I always get confused with my partner John.
Yeah.
By folks too. So, but I think you pretty much covered it. I'm currently the chair of the legislative committee for NACPA, and we're among other things, obviously one of our huge priorities over the last 4 or 5 years has been student loans, and I think we're starting to finally see some payoff to the work that a lot of people have done on that front with regards to bankruptcy in particular.
Well, I know it's just as frustrating for you as it is for me, and it has been over the years, to not be able to help folks that come into our offices that are overburdened with student loan debt. We have been able to help in some instances. You, in fact, have done some very interesting programs there in North Carolina, but we haven't been able to discharge student loans except under very, very, very limited circumstances. So I know the National Association of Consumer Bankruptcy Attorneys, NACPA, has played a very important role with this new legislation. It's called the Fresh Start Through Bankruptcy Act. Tell us a little bit about this legislation and how it came to be, Ed.
Well, the two sponsors of this bill in the Senate are Senator Dick Durbin, the Democrat from Illinois, the senior Democratic senator from up that way, and the big news for everyone on this is that John Cornyn, the senator from Texas, who is a Republican, is the other co-sponsor. Dick Durbin has introduced for many years now, maybe going back 10 years. Various student loan discharge bills, and for the last several years, he's sought just a complete return to the dischargeability of student loans, like credit cards and medical bills. They wouldn't be treated any differently. This year, with the Democrats having razor thin control of the Senate right now, basically with a 50-50 split with the Vice President Harris casting any deciding votes. They've been able to advance legislation a little bit more, but there's also been, for all of the reasons that we've seen through Congress, but a lot of attempts to try to have some bipartisanship. And Senator Durbin really, reached out to across the aisle and found a partner in Senator Cornyn here, who is looking at student loans as a problem that's hitting everybody, regardless of whether you're a Democrat, Republican, whether you're in Texas or Illinois, Alabama or North Carolina. Everybody, people are seeing this. I think, and it's not a problem that's getting better because, a lot of folks have compared this to the mortgage crisis that we all went through back in 2007 and 8, 9 and 10 and such. The real difference there is that as awful as losing your home to foreclosure was, right, Brad, you could get rid of that debt and get a fresh start, right? And 2 or 3 years later, very often you'd be able to buy a new house again, right? Especially if your finances recovered and you were able to take advantage of bankruptcy and clear the rest of that stuff away. The difficulty with student loans is there is no ability to get that fresh start. You can never. The only way to get rid of your student loans are either to pay them or to die, and that's where this is a problem that's not going away. And I think more and more people in Congress have recognized that.
Well, it's much needed legislation, and I want our viewers to understand we're not promoting today just do away with student loan debt. I know a lot of hardworking people have paid off student loan debt over time. What we're saying is that if your financial problems are insurmountable and you're at the point where you need to seek bankruptcy protection, that student loans shouldn't be treated any differently than MasterCard or Sears or your doctor's bills. They're general unsecured bills, and you should be able to get the fresh start that bankruptcy provides. Now, let me say this before. Go ahead, Ed.
No, I was going to say, what's really important about that is there have been a lot of calls, particularly from our friends on the left side in Congress, for more general student loan forgivenesses, a student loan debt jubilee, so to speak, where everybody would be given $10,000 or even as high as $50,000 off their student loans.
Right.
There's a lot of problems with that, right? And and obviously you and I are a little self-interested as bankruptcy attorneys, but the problems with those problems hit on both ends of the spectrum. Is for some people, $10,000 or even $50,000 isn't going to make a huge difference, because I don't know about you, but it used to be if you see somebody with $20,000, $30,000, even 15 years ago of student loans, that was a lot. Nowadays, $100,000, does that even make you pause, right? I routinely have clients with $200,000-$300,000 of student loan debt, and my record holder is a woman here in North Carolina with $1,058,000 and change. I round off because after you're above $1 million, what's it really matter, right? More than $1 million of student loans, and so. What does $50,000 mean to her, right? Nothing. It changes nothing. She's still got more than $1 million of student loans. But the other end is, if you cancel this for people who are trust fund babies, how does that make any sense when they or somebody who's a lawyer who's getting out of law school, going to work for some tall building law firm making $250,000 and they get a $50,000 bonus from the federal government? That makes no sense either. And it's also unfair. The people who have worked hard, paid their student loans, or avoided student loans in the first place because they did everything they could to avoid this, and they are treated worse than those. Bankruptcy solves a lot of those because it sorts those people out. That rich, brand new lawyer, he's not getting a bankruptcy discharge very easily, right? Anybody who files, they're going to take the hits that bankruptcy does provide. There's no lying about that. So there is a deterrent that bankruptcy isn't going to be something people do just for giggles, right? So I think there's a lot of advantages to this being a key part of the student loan solution.
Yeah, and Ed, to underscore what you said, a lot of people have a negative perception of who the individual is that seeks bankruptcy protection. I've been doing this a long time. I've been doing this for over 30 years. You've been doing it for a long time. I can tell our viewers that the vast majority of the people that come to see me are people that didn't want to come to see me. They don't want to seek bankruptcy protection. They don't want to take that step. But bankruptcy is there to give an honest debtor a fresh start, a chance to start over, and it plays a very important role in our society and in a free enterprise type system. People just wouldn't go out and take chances. People wouldn't go out and build businesses. People wouldn't go out and try to better their family if that safety net of bankruptcy didn't exist. So I believe very strongly in what we do. And I can tell you from experience that the average person that comes to see Ed or myself for assistance is a good, hardworking person that didn't want to be in one of our offices. And let me say at this point, we want to talk more with Ed about student loans and this new legislation. But we are also both aware that many of the people watching this video are having financial problems right now. This last year and a half has been tough. We know people are behind on mortgage payments. We know people are having a hard time with rent. There's been protection up to this point. In fact, there's currently a moratorium that will go on until at least the first of next year on student loan collection. But folks, if you need help, be proactive. Reach out for help before the garnishment comes, before the foreclosure starts, before you're worried about your car being repossessed. Our firms offer absolutely free initial consultations. Ed, I'm sure that like the Bond and Bodas law offices right now, we're offering consultations from the safety of your home or your office. We'll do the meeting by phone or by video like Ed and I are meeting today. We want to help you. And I can tell you from experience, the sooner you get out in front of the situation, the more good we can do to help you. So contact information will be available for both John Orcutt's firm, and I've mistakenly called Ed John a couple of times already. I've known John even longer than Ed. John is so well respected in this field, and Ed works with John there in North Carolina. So if you need help in North Carolina, John Orcutt's firm and Ed Bolts are the people to talk to. If you're in Alabama or Mississippi, the Bond and Bodas law offices are located throughout Alabama and Mississippi. And again, we're offering absolutely free initial consultations now. So please reach out for help. We'd love to help you if we can. All right, let's dig into student loans in bankruptcy. Ed, we both have practiced long enough to be able to say that this legislation, if passed, would essentially put the rules back to what they were some 20 years ago. It used to be that after student loans had been due and owing for a certain period of time, they became dischargeable in bankruptcy. So many of our viewers are, and many of the people that have called me already are very enthused about the fact that student loans will become dischargeable if this legislation passes, but it's not all student loans. So tell us exactly what this legislation would do if it were to become law, Ed.
So the first split is that the dischargeability would only apply to government guaranteed student loans. This wouldn't apply to private student loans, which would be still subject to the undue hardship analysis, and also, but those private student loans are a much more complicated beast, because as we've seen in 3 different circuits across the country, unfortunately, I don't think in either of our circuits we have any cases on this yet, but in the 5th, 2nd, and 7th circuits, I think now, they've all held that some things that creditors call private student loans are not actually student loans. And that's a very complicated analysis, and I think it's very well founded, and it's based on a very good reading of both the Bankruptcy Code and the Internal Revenue Code. So it's a pretty complicated one. But this bill, the Fresh Start Through Bankruptcy Act, doesn't apply to private student loans. There's other opportunities that people have. Those are subject to statutes of limitations, which I've had some real good success. I don't know, with beating those here, especially in North Carolina. We've got a pretty short statute of limitations on collection for those. But this would only apply to government loans. And that's government loans that are through, whether it's through the Department of Education, or one of its servicers, such as Navient, which used to be called Sallie Mae, which is, of course, very confusing because Navient handles both private and government student loans. People will say, "Oh, I've got Navient, they're government loans." I'm like, no, I don't know yet. You have to figure it out. And then there's the others like Fed Loans, Mohila. There's a handful of student loan servicers out there who handle these.
Let me interrupt just for 1 second. Ed is making an important point here, folks. You know, you hear headlines, student loans are dischargeable in bankruptcy or will become dischargeable, or private student loans are now dischargeable in bankruptcy. These are very complex analysis for both private student loans and for federal backed student loans if this legislation were to pass. You need an experienced attorney. If you're looking at these type of issues, most of us are offering absolutely free initial consultations. You need an experienced bankruptcy attorney. Ed, I don't know if it's the same. I suspect it is in your part of the country, but you know, when the financial times are hard, then you have a lot of attorneys that really haven't done a lot of bankruptcy work jump into the bankruptcy field thinking they're going to make money. Folks, it's important that you talk to an experienced bankruptcy attorney if you're having financial problems. If you're not in North Carolina, if you're not in Alabama or Mississippi, National Association of Consumer Bankruptcy Attorneys, again, has a great link on its website at NACBA.com, NACBA.org. I'm sorry, it's on your screen, where you can find a NACBA member in your area. I'm sorry, but I wanted to interrupt because we talk about private, we talk about federally guaranteed, or we talk about statute of limitations and different circuits. They're complex issues, and all the more reason you need an experienced attorney like Ed. So I'm sorry for interrupting, but go ahead with the analysis if you would.
So the second part of this in regard to the government student loans is that they have to be in a collectible for more than 10-year period of time, which is another part that's difficult. When I first started working for John Orcutt back in 1998, student loans were still dischargeable for 2 weeks if they were more than 7 years old. And as I was trying to figure those out, John told me, don't try to figure it out. It's only 2 weeks. I hate it because it's impossible to know whether enough time has passed for them to be dischargeable. And he said, you inevitably file the case 3 weeks too early, and then you have to deal with a whole mess of that. Because back in 1998, it was almost impossible to know anything about somebody's student loans. So I didn't learn anything about student loans back then. I've since spent a lot of time learning about student loans. I think one of the advantages now is that while it's not perfect, and you can get a student loan payment history from the Department of Education. The one that's generated by the Department of Education is, like a lot of government documents, very hard to decipher. So a lot of times, I particularly use a separate company called Student Loanify to pull those documents, and that gives you the full student loan history. Because especially if this bill goes through and is enacted, it's going to be very important to do a calendar workup to figure out how long those student loans have been in collection, because periods of forbearance or non-collectability stop the clock in essence. So and you have to know when the clock started, because it starts generally 6 months after graduation or leaving the school. But it may be told because you go back to school, or some student loans might be ticking along where other ones aren't ticking along. So it's going to be, again, a fairly complicated set of calendar counting to figure this out. We're in better shape than we were 22, 23 years ago, because we will be able to gain access to this, but it's going to involve a fair amount of math and counting up days to see, all right, when is it going to be safe for this person to file bankruptcy so that they can get rid of their student loans? Because this thing I can guarantee, you're not going to be able to call Navient and say, hey, are my student loans dischargeable in bankruptcy yet? Because they will just hang up the phone and send your case to start garnishing your paycheck right away. So,
and I guess the flip side, though, is although it will be easier today than it was 20-odd years ago to determine the status of the student loan, there have been more programs developed over the last 22 years that will put student loans into a non-collectible type status, whether it's income-based repayment plans or...
The good news on that is that all of the income-driven repayment plans, and those started, like you said, Brad, the first one was the income contingent plan that started in 2007. Those are considered by the Department of Ed as completely contractual payments. So the time spent in one of those plans even if your payment is $0 a month under that plan, that counts as time spent repaying your under a repayment status. So I think that's good news. And ultimately, what that's going to mean is that's going to, in a lot of circumstances, going to mean that our clients are going to need to be in the umbrella term for all. There's 4 kinds of them. There's income contingent, income based, pay as you earn, which is PAYE, and revised pay as you earn, which is repay. All of those are called income driven, and those will count, but they're going to be, in a lot of circumstances, an option that our clients are going to need to do to sort of tread water till they can get to that 10-year period of time. But that's going to, adding bankruptcy on top of what's already a really complicated system is going to oftentimes require attorney assistance also on that to make sure you get it right.
So see, folks, this is why it's so important. I've practiced bankruptcy law for over 30 years, and I just learned something from Ed. I didn't realize that as long as they were in one of those programs. And of course, it's been over 20 years since I've really had to deal with this issue, but that there's still that time period will be accruing. So that's fascinating. Let's kind of go back to the beginning. Why are student loans not dischargeable in bankruptcy? Why do they have this special status, in your opinion, Ed?
Well, I think most of the kinds of debts that are non-dischargeable in bankruptcy are because you've done something wrong, right? You haven't paid your child support, right? You injured somebody in a drunk driving accident, right? You haven't paid your taxes. But only for, but even when it comes to taxes, it's only for, for a certain amount of time until the government's like, all right, we're going to let you off the hook. Student loans are really unique in that they're the only debt that is non-dischargeable in bankruptcy, right? Where you're encouraged to get that debt, right? Everyone says, go to college, get an education. That's the key to the American dream. Going back, to my grandfather under the GI Bill and probably even before then, right? College is the way to move up the ladder here in our country, and that's true. But it's a bit unfair that those become non-dischargeable. And the main reason has the stated reason has always been, well, we can't take your education away from you, so you should so the government needs to get that money back. The truth is that a lot of the time that student loans, when the bankruptcy code was enacted back in 1978. They were completely, prior to then, they were completely dischargeable. Even after 1978, they were dischargeable with a 5-year wait in a Chapter 7. And always, if you filed a Chapter 13, you could get rid of your student loans. But over the next 20 years, from 1978 through 1998, the government slowly ratcheted that down. And it went from being a 5-year waiting period to a 7-year waiting period to applying in Chapter 13 also, to this undue hardship standard, which has been made just more and more brutal and cruel by the courts over time. One of the reasons for that has been because that was a way that senators who wanted to increase funding for student loans could balance, could lower the cost by saying, well, we'll always collect these. And they told a nice sweet lie there, because right now, I think the last number I saw was now up to $1.8 trillion of student loans that the federal government guarantees. And they pretend that every single penny of that is going to be collected. And none of that is marked against the budget as part of the deficit at all. Even though more than a third of that is in default, meaning that people have gone more than 9 months without making a single payment, but they still count that as completely collectible. No other business would do that. It's just a way of keeping it off the government's books, and it ends up hurting people, because they resist discharge. So, that's sort of the historical and the skeptics' view of why student loans are discharged, I guess.
Well, and of course, the point you made earlier, it's become so much more important because the amount of student loan debt that people hold is so much higher. I went through 4 years of college and 3 years of law school and did it almost all on student loans. And I think I owed somewhere around $70,000, after 7 years of school. As you've said, people come in today and they owe hundreds of thousands of dollars of student loans, and they don't have a professional degree. They may, have a cosmetology degree, which is a very worthwhile degree, but it's hard to pay off a couple $100,000 as a cosmetologist in student loans. And what we find is people are in just this endless cycle. They can't even pay enough monthly to pay the interest that's accruing on a monthly basis. So these loans negatively amortize and they just grow out of control.
Right.
And so it looks like we may have lost a connection with Ed. I'm sure he'll be back shortly, but I can tell you that this issue is one of the most important issues we face as consumer bankruptcy attorneys. People come to us looking for a fresh start. They need a chance to get relief from those creditors' calls, to stop a wage garnishment, to be able to protect their home, to provide for their family, all things that are very, very important to consumers here in our country. But we can't, in many respects, help them. The standard that has existed for the last 20 years or so, in order to discharge a student loan in bankruptcy, you had to show that the debtor suffered from an undue hardship. Those are legal terms, but essentially that means that we have to be able to prove to the court that not only can the individual not pay his or her student loan debt at this time, but they're not going to be able to in the future. So they have to have, in many instances, some sort of permanent impairment that's going to keep them from making money for the rest of their life. There's no other debt like this. Taxes become dischargeable after a period of time. If unfortunately you lose your home through a foreclosure, you can discharge whatever you owed on that mortgage and get on with your life. But student loans are like an anchor around people's neck, and they keep them down for many, many years. And I'll tell you that that's not the best thing for our society. You have people out there with degrees, and they're not really able to contribute like they should because of the student loan hardships that they're dealing with. Ed, welcome back. We had a there. No problem. It's happened before on this broadcast. So we know that the problem exists, and now, thanks to the efforts of NACBA, this legislation with bipartisan support has been introduced in Congress. I do want to put in a plug for NACBA now. I know some other bankruptcy attorneys watch these Facebook Live events. If you practice consumer bankruptcy and you're not a member of the National Association of Consumer Bankruptcy Attorneys, you should be. The cost is very nominal, and the benefits are vast. In addition to annual conferences that are done across the country this fall, you'll be meeting in Hawaii. We'll be meeting. I'm a NACBA member. But the listserv events, the other information that's available to practicing bankruptcy attorney is just invaluable. So there's my plug for NACBA. All right, so Ed, the legislation has been introduced. It has bipartisan support. What should we look for moving forward now?
Well, I think what, hopefully we're looking forward is to that Senator Durbin and Cornyn are looking to gather more support from first some more Republicans, because a stampede of Democrats tends to scare other Republicans. So I think the hope is that there was some solid support during the hearings that were held. I think it was last Tuesday. The hearings were held by the Senate Judiciary, where there was real support expressed by some other Republican senators, including Josh Hawley from Missouri. Even Charles Grassley from Iowa, who has been has a real hard nose when it comes to bankruptcy, has said he's interested in this bill, because part of what this the bill also does, and this is where I think it's also changed the dynamic. In addition to there being the 10-year waiting period, there is the Department of Education is then required to start a new data gathering about default rates and the amount of student loans discharged by debtors from various universities. And if that rises above a certain level that's going to be set by the Department of Education at some future date, then they could seek a clawback from those schools. And part of the logic of that is that if a school keeps charging people for education that isn't, and those people aren't able to benefit from that, that perhaps the school should have to pay some portion of that money back. That's a bit controversial on the blue side of the aisle, but that's part of what's gained support on the red side. And that's where we're starting to see groups like the American Enterprise Institute just the other day came out and said that they support this. They phrased it as as long as people are in repayment, which isn't exactly what the bill says. You don't have to be paying, you just can't be in a forbearance. So if you fall behind, you're not necessarily punished. But we're starting to see conservative groups look at this because it is more of a middle ground compared to the student loan forgiveness for everyone that has been advocated by others in Congress.
So I saw today that even the American Bar Association came out in favor of discharging student loans in bankruptcy on even apparently an even broader basis than what's been proposed in this legislation. So for our viewers out there that may be dealing with insurmountable student loan debt, the name of this legislation, and I'll write it again here, is the Fresh Start Through Bankruptcy Act. It's on this Facebook Live video, and it'll be on our Facebook screens going forward. Call your local representative. Ed, I met with a conservative member of the House of Representatives from Alabama here not long before COVID, and went in to talk about dischargeability of student loans in bankruptcy. And he immediately thought I was, touting just forgiveness of student loans in general. And when I emphasized the point that I said, no, we just want them to become dischargeable in bankruptcy. He had no idea that they weren't dischargeable in bankruptcy. Mm-hmm. So I encourage folks out there, call your elected representatives, encourage them to support this legislation, let them know about the hardship that student loans create for individuals. So there's bipartisan support. This legislation is moving forward. If I'm out there and I've got money problems right now, should I be putting off talking to a bankruptcy attorney because this legislation may become law in the future?
I think the opposite is true. You may decide to hold off on filing a bankruptcy, but maybe not even then. But I think it's important to talk to an attorney because there are other, one of the other complications that has to be worked out with this is that, as you said, Brad, that going back about 10 or 15 years, they started coming up with these income-driven repayment programs. And part of what a lot of people do with those is they have, a student loan basically for each year, each semester, maybe even that they were in school, right? And so, 4-year college, you have 8 different student loans. They may all be with the same lender, but a lot of times people look when they're getting into one of these income-driven repayment plans, and they go and they consolidate those student loans all into one for their repayment program. And one of the problems that this bill we're working to clarify is that if you consolidate those loans, it may not be the original date that you got the loan or where it started repaying, but the consolidation date. So one of the things I'm advising clients right now is hold off on consolidating your student loans because that might not be the right choice, depending on how this legislation clears up. And we're working to make sure that people aren't punished because prior to 1998, the case law said a lot across the country, a consolidation is a new loan, so that's the date that you start from. And that's contrary to the intent, I think, that anyone has here, especially because people have been very much encouraged since 2007 and more recently, consolidate. That's the best thing to do. And so we're working on that. But you want to talk to people about that, a lawyer about that to make sure you're making the right choice. Because it's a difference of if you were in repayment now for 9 years on your student loans, you definitely wouldn't want that clock to start over. If you were only a year or two in, but the consolidation lets you get your payments substantially lower, then that might be a better choice. But I think it's important to talk to a lawyer about that.
More importantly, it's important to talk to an attorney with experience in this field. I always tell folks, Ed, it's kind of, counterproductive. I'm a bankruptcy attorney, but if somebody comes in to talk to me, my first objective is to look at non-bankruptcy options. And a good bankruptcy attorney, as you just demonstrated, is going to look at the big picture. Yeah, if your student loans are 9 years old, if they may become dischargeable if this legislation passes, we may want to look at options in that situation to postpone a potential bankruptcy filing. If you're a year out of school and your loans wouldn't become dischargeable for another 9 years anyway, and in the best situation, and you otherwise need bankruptcy protection, then a bankruptcy may be appropriate at this point. But those are discussions you need to have with an experienced attorney. And if the bankruptcy attorney you consult with can't answer these type of questions, then you need to look a little bit further and get another opinion in mind.
Absolutely. Especially because, sometimes you need a bankruptcy for, it's not the student loans that are the problem today that are the number one problem. There's a foreclosure or a auto repo or a credit card, are threatening to garnish your wages too. And so a bankruptcy might be necessary to deal with those things, but an experienced attorney like Brad or I can help structure your bankruptcy so that you're able to continue to remain in that income-driven repayment plan, whether that's by filing a Chapter 7 and staying in it, or filing a Chapter 13 and having a plan that specifically allows for that is very often possible through, with an experienced lawyer who knows what they're doing, being able to guide you through that process, where other attorneys just sort of throw up their hands because you end up with, when it's, you're starting to get to a specialty of a specialty, Yeah,
excellent point. Ed, I'm going to take a little break here and talk a little bit about our law practice and your practice. I'm going to give you a warning. We're going to take some questions from our viewers after that, and then I'll try to finish within the hour, and I'll give you a chance to say something at the end in case I've missed anything important. But for our viewers, this is the Bond and Botus Facebook Live that we do weekly. We try to talk about topics that are important to the folks that we represent and the people we assist. We know a lot of you have had financial challenges over the last year and a half. Nearly everybody has. It's been a tough year and a half. Many of you haven't had to deal with these problems because there have been moratoriums on foreclosures and evictions, student loan collection. But the rubber's going to meet the road soon. And if you see financial problems in your future, we encourage you to reach out in advance. The Bond and Botus law offices are located throughout Alabama and Mississippi. John Orcutt's law offices, where Ed Bolts manages the practice, are located in North Carolina. Our firms offer absolutely free initial consultations with an experienced bankruptcy attorney. For your safety, we're doing these consultations if you choose, either by phone or by video, whatever you're comfortable with right now, but there's no cost and there's no obligation. We're just going to talk to you about what your options may be in the future. And we want you to know what the bankruptcy code offers should you need bankruptcy relief in the future. So please, if you know somebody that's having issues with student loans, our Facebook Live episodes live on our firm's Facebook page, and they're on our website. If you know somebody that may benefit from the excellent advice shared by Ed Bolts today, please refer them back and encourage them to watch and share these videos. We've done other episodes on student loans. We've done episodes on foreclosure, on eviction, unemployment compensation, many important issues out there. So I encourage you to share this information with folks you know that may be impacted by debt right now. So Ed, if you're willing, we've had a few questions that have come in from our viewers, and I'm going to give you a chance to address them.
All right.
We'll address them together. So the first question, I think we've already answered, and that is why student loans aren't dischargeable in bankruptcy currently. We've given the history of the dischargeability of student loans and the interests that have influenced Congress one way or another. Ed, this next question, if I missed student loan payments during COVID, is this bill going to be passed before I have to start paying on it?
Well, I guess if I had that sort of crystal ball, I would probably, be rich and wealthy sitting somewhere else. But so I don't. It's unclear, how quickly this bill might move, because right now it's just been introduced. It's a long, torturous process through Congress. Especially since it has to go through both houses and then ultimately, for signature by President Biden. So I don't know what that I'll, with payments starting to come due in January, we can hope that this bill might pass before then. But I wouldn't be able to guarantee it. And that's why I think, again, to repeat what Brad has said, it's better to start talking to an attorney like him or me before then. So before the moratorium ends and before your payments start coming due, so that you can make appropriate plans both for what we hope will happen of student loans becoming dischargeable again, but also in case that isn't the case, the situation, so that you know how you can structure your finances so that you will be able to make a payment on your student loans without anything. Because otherwise, the danger is with just 30 days notice, by a letter in the mail, the Department of Education and the student loan servicers, they can take up to 25% of your paycheck, just zoinks, and it's gone. And there, it doesn't even have, you don't have the same rights you would compared with a judgment garnishment or anything like that, or even an IRS garnishment. The Department of Education is truthfully the most powerful creditor in the United States, without a doubt.
Yeah. I can just supplement that by letting our viewers know, and if other bankruptcy attorneys are watching, I've been a member of NACBA for many years, and I know when significant bankruptcy legislation comes before Congress, it can move painstakingly slow. We talked about bankruptcy reform legislation from the late 90s all the way through the early 2000s, and it was 2005 before legislation finally passed. And when it did pass, it wasn't at all what we had expected up to that, up until the months before the legislation passed. So although we're enthused and excited about this potential relief that may become available to student loan debtors, you shouldn't hang your hat on this alone right now. If you're having financial problems, please reach out for help now. It doesn't cost you anything. And get some advice as to how you can protect your paycheck going forward. Next question, what will happen if I cannot make payments once my student loan is unfrozen? I assume this individual is talking about when student loan collection comes out of forbearance. So what can that debtor do, that individual that can't make their student loan payments?
Well, I think, the first things that happens with student loans is if you're more than 30 days behind, those loans are considered delinquent. And if you go more than 9 months without a payment, then you're in default. And once you're in default, that's when bad things can really start to happen, very, very quickly, because then the Department of Education, can garnish your wages for up to 25%, as I just mentioned. And that includes Social Security. So if you're retired or disabled, they can take those wages too. They're the only, other than child support, they're the only kind of creditor that can do that. They can, in many places, they can interfere with your ability to get professional or even driver's licenses. They can intercept your any tax refund you may be entitled to. So I think that the key to that is that once the period, the moratorium ends in January, you need to have a plan for what you're going to do for repayment. And that there's lots of options in that regard. Among those, again, are these income-driven repayment plans. and they are exactly what they're described as. They're based on your income, and your payment under an IDR can be as low as $0 a month. And obviously anyone can afford zero usually. And that keeps you in for at least the next year in making you're making payments, quote unquote, even if it's very small amount. It may not even be enough to cover the interest, which is incredibly disheartening, I know, because you're looking and you're struggling and doing your best, and that balance goes up every month. They send you a new statement that it's gone up and up and up. But that may be the best way to control it. Another way to control your student loans is, if necessary, to file a Chapter 13 bankruptcy, because while they're not dischargeable in Chapter 13, as Brad knows, right? They're not. They get paid just what's available to your creditors, which often can be very little, if nothing, also. And the advantage of a Chapter 13 compared to these income-driven repayment plans is that it looks more at your actual circumstances and your income and expenses and your other financial problems too. So you're able to get those student loans at least held off. You may not be making progress, and it may not count towards any forgiveness period, both inside or outside bankruptcy. But sometimes, when you have a really bad cut, sometimes you just need to stop the bleeding, and that's the first thing you worry about.
Ed, and I don't want to get too deep in the woods here right now, or too deep in the weeds, but you just answered a question I had. While you're in a Chapter 13, if you're not able to make an income-based payment while in the Chapter 13, the time you're in the Chapter 13, as the legislation is written now, would not count towards that 10-year period of time. Is that correct?
I believe that would be the case, because under the Higher Education Act, if you're in the period you're in a bankruptcy, because those student loans are non-collectible, and this actually would apply for the much shorter period that somebody's in a Chapter 7 also. But the time that you're in a bankruptcy, you're in what's called an administrative forbearance. So that time would not, absent a bankruptcy that specifically allowed for that, you would not be able. The clock would stop ticking. In a Chapter 7, a Chapter 7 case usually lasts 4, maybe 6 months in most circumstances. So that's not the same big deal. But a Chapter 13, not unusual to see a 5-year Chapter 13 plan at all, right? And and that you need to know that going in that isn't counting, and that you need to take that into consideration and think about whether that's the right choice for you to go that way or not, right? Or to structure the plan correctly.
Perhaps it will give encouragement to some courts across the country that have not allowed these income-driven repayments while in Chapter 13. I know you've had some success there in North Carolina, and courts in other parts of the country have allowed these type programs.
Yeah, there's been an increase. The bankruptcy court in the Eastern District of Pennsylvania just adopted a program. All 3 of the bankruptcy courts in Florida are allowing this under various requirements. I know that in Nevada they're also considering it, because one of the things that has been a slow but steady change is that more and more of the bankruptcy trustees and even judges have started to realize that even with the bankruptcy code as it is, they need to do something to make bankruptcy effective, or at least not make student loans worse for people. Because right now, one of the things that I've talked about is that, Albert Einstein said the most powerful force in the universe is compound interest, right? And that plays out really hard with student loans, because if you're in a 5-year plan and nothing gets paid on your student loans, you can go from owing $100,000 on those student loans to almost $150,000 at the end of 5 years, and that can wipe out a lot of times the relief that you got with your other debts. And more judges have started to realize that turns the fresh start of bankruptcy into a false start, and are looking to it. But then there's other judges who are, much more hidebound and just don't want to change and don't understand why student loans should be treated better than Discover Card in your county hospital, right? So you've got them too.
Yeah, we could have a whole separate conversation on that, and I hope we will at some point in the future. But again, important for our viewers to know there are a lot of issues concerning student loans in and outside of bankruptcy, and the answers are different based upon what part of the country you live in, and the judges in the particular jurisdiction in which you would seek bankruptcy protection. So, again, important to have an experienced attorney. This question doesn't surprise me. I've had this asked before, and the question is, can I be put in jail for not paying my student loans?
I don't, generally, no. Not that that doesn't stop some rogue judges from doing terrible things some days. But in general, we don't have, debtors' prisons are for private debts, even government debts like this. You shouldn't be put in jail absent something much worse on your part. So no, that you can't be put in jail, particularly for government loans.
Yeah, and folks, don't ever trust any attorney, including me, that guarantees anything. That there might be some situation where some judge could hold you in some sort of contempt for not making payments, but the answer is no. Generally, you can't be jailed for a civil an obligation to pay money. Criminal fines, those type of things are a little bit different, but student loans, if you can't pay it, you need to talk to an experienced attorney so your paycheck isn't garnished, so that 25% of your pay doesn't disappear, but they can't throw you in jail for it. All right, good question here. Do I have to declare bankruptcy to handle my student loan debt?
No, you can just pay your student loans. That's one option always. You can also, again, enroll in one of these income-driven repayment plans through your student loan servicer to make progress. And in many cases, particularly if you work for the government or for most nonprofits like a church or the Red Cross or many universities even, you can get your student loans forgiven after 10 years of repayment, which is the amount of time you'd have to wait for a bankruptcy discharge anyway. So you may be able to avoid bankruptcy in those circumstances. I know I've also seen articles about how sometimes the best option is just to run off to the jungle of Central America or go live in a monastery in Tibet or something like that because they can't garnish your wages there. But that's a little bit more extreme.
Yeah, I think something important to communicate to people right now that there is, and again, we're talking with government student loans now, but there is a way to get rid of student loans outside of bankruptcy if you're fully disabled. And we do have people that come in to see us occasionally that are on disability. They can't work. There is a manner in which to seek an administrative discharge of that student loan obligation. And it's much simpler based upon my experience than a bankruptcy. So, if student loan debt is your only issue and you are suffering from a disability, there are some administrative remedies outside of bankruptcy that will provide relief.
That's always been one of the odd things is that the Department of Education will agree to the total permanent disability discharge while fighting an undue hardship discharge in bankruptcy. And it makes the end result is the same in both circumstances. They don't get paid, but they will fight tooth and nail the undue hardship, with the only real explanation being that they don't want people to get in their head that bankruptcy might work and tell their cousin, oh, I got rid of my student loans in bankruptcy, because their cousin will try too. Because particularly a lot of the student loan collection companies, there's one in particular, ECMC, they practice a scorched earth campaign, and they fight every case tooth and nail, and make it very difficult.
Yeah, and it's a problem for bankruptcy attorneys because an individual that can't pay their student loan debt, they're in a tough situation, that they're facing a disability. To try to get a student loan discharged in bankruptcy based upon an undue hardship is a protracted, often proceeding. So there aren't monies available to compensate an attorney to do that. You know, there are some options, but it's tough. It's a tough system, and that's why this legislation that NACPA and that Ed Bolt's back is so important, and we hope it becomes law. Let me sneak in one more question here. Do I have to wait until 10 years after I receive my student loans to seek help?
Well, first you have to wait until this law passes. So, you know, there's that. But again, you shouldn't wait until that period of time to seek help, because you need to do it. There's always, the earlier you talk to Brad or me or people at our firms, the sooner, the better advice you're going to get, and the better plans you can make to make sure that that bankruptcy is ultimately successful and you get the maximum benefit out of it that the law allows. So again, I wouldn't wait that whole 10 years. I would start talking to an attorney earlier. You know, there's no time that is too early to start talking to a lawyer about these sorts of things.
Yeah, absolutely. And especially since the initial consultation is at no charge to you. Things can happen fast, and it's hard for us to do as much good for you right before a foreclosure or after a student loan garnishment of your wages has begun, or after your car has been repossessed. If you get to us when you know that you're going to start getting behind on your mortgage, or you know you're going to have a hard time with your student loans, whatever the obligation may be, the sooner you can come to us, the more help we can give you. Ed, I want to be respectful of your time. We're up against the hour. I want to thank our viewers for listening in today. Again, I encourage you, if you know somebody that's dealing with overwhelming student loan debt, please encourage them to watch this video. It's across the bottom of our screen now. I know it's important at Ed's firm. It's important at the Bond and Bodas law offices and John Orcutt's law offices. We're all about faith. We're all about family, and we're all about helping you take care of your finances. Ed, anything I may have missed? Anything you may want to add for our viewers before we conclude?
No, I just want to thank you for having me this afternoon, Brad, and all of your viewers. And I hope people reach out to one or both of us to get some help when they need it.
Well, thank you. Thank NACPA, and we hope this legislation becomes law. So we'll talk to you soon, Ed. Thank you.
All right. Bye-bye.
Bye-bye.